All right. It is, I believe, Tuesday, and I don't have a headache tonight, which is good. Last night was actually pretty fun, even though it was very difficult to do. Tonight, we're going to start with Article 2, but I do want to say a couple of things like I usually do before we get started. Most of everything I speak about as far as material, you can find it at pCloud. So the evil twin, my evil twin from Alfred Adask, that's at pCloud. Obviously, the articles that I use, like this industrial property, the protection of industrial properties at pCloud. The book that I mentioned last night, looking backwards, I found a PDF, so I was able to put the book up at pCloud. So if I can find hard copies or PDFs of things that I reference, I put them up at pCloud, just so you know that. But some of the books, like Gilbert Law Summaries that I reference occasionally, you're going to have to buy one of those. I would actually advise people to buy their own Black's Law 5th edition in hard copy, as well as the Gilbert's Law Summaries on property. That would be a good one, because that's really what we're always talking about, property. Everything that's going on planet Earth is about property. Whose is it and who can prove it? So this week is about your property. It's about the industrial property. It is what property can you actually lay claim to that is yours and exclusively yours. Let me try to get my head wrapped around a couple things here real quick, because I use a lot of different articles as I go through. Last week I told you that the article called Possession as the Root of Title is going to keep coming back. It's actually woven throughout this whole 6 weeks. That's probably one of the better articles to read specifically that's up at pCloud. In fact, I'll just take mine real quick. I'm just going to look at it. I'm going to anywhere in that article, page. This is again. I'm just picking up Possession as Root of Title, just as an example. On that document, page 1224, there's a paragraph called First Possession. The rule stated. I can go almost anywhere in this document and find something that pertains to everything I talk about all the time. I'll go down to the second paragraph here. It says, both the court and the dissent assumed that the only proper mode of acquiring ownership of unowned things was taking possession of them. That line right there, the courts have already agreed that you must have possession of something. And then first possession's the absolute. An a priori first possession is ownership, according to every court. But again, when I find a sentence like that, you got to really think about what they're saying. It says, both the court and the dissent assumed that the only proper mode of acquiring ownership of unowned things was taking possession of them. Look at what they put right in the middle of the sentence, is unowned things. Unowned things. And that's what I'm getting at. You got to be really careful when you're reading these, because sometimes you think you know what they're saying, or you think you know what you're reading, but the one word or two words that goes into a completely different direction, or starts to start a new discussion on something unowned things. In other words, if something is already owned, there's no argument. If something is already owned, there is no argument. Almost everything going on in the courtroom is because they're dealing with unowned or unclaimed property. There would be no argument if everybody laid claim to their life. There would be no argument. There would be no trust. There would be no equity. There would be nothing. It would be your life, and it would be all yours. Your property would be yours. You'd never end up in court. You wouldn't have a driver's license. Everything you thought the world should be would be that way if everybody claimed their life from day one. But they created a really interesting world, or parallel universe is what I call it. It parallels you. By the way, for those that don't know it, the word universal means Catholic. That's just a side note, by the way. I'll probably be sipping off my coffee most of the night just to try to keep my throat lubricated. What I'm getting at about these articles, especially possession as the root of title, that article is worth reading multiple times. And you will, like you said, all of these articles that are up at pCloud, if you just pull one off, when your mind is in the right place, you're going to start seeing this stuff. And then once you start seeing it, you're going to start seeing more of it. And then the more that you do see, the more you're able to see. And then when some moron comes up and starts talking to you about the 14th Amendment, you can just kind of either smile and just think, well, how sad it is to be there. Because it's a long way from where you're going. It's a really long way to get to where I'm at least mentally. It's a long way because there's so much weird magic. There's so much stuff that we refuse to accept. We refuse to accept them. So I'm going to go ahead and get started with the document for the week, and that again is the protection of industrial property, the Paris Convention, basically of 1883. I ended last night. In fact, it's funny. I babbled on for nearly 2 hours on Article 1. Article 1 is everything. Industrial property is everything. Patents, utility models, industrial designs, models, trademarks, commercial names, indications of origin, appellations of origin, repression of unfair competition, which would be antitrust. It's commerce, it's industry, agricultural, it's everything. Industrial property is everything. In fact, again, I wasn't planning on doing this. Let me go grab the document I turned in or I recorded at the county. Hang on a second. I'm taking a short walk into the other room. Again, I said this the other night. I said that, I can write 33 words where somebody else might write 80 pages because I'm using specific words. The industrial property, the concept of industrial property, I actually put in my last notice. Let me see if I can find it. The final notice, it's actually my affidavit that I put on the record, which is based upon Minnesota Rule 220. The very last line, it says, as the genuine baby and one of only 2 owners named in said certificates of title, it was never my intent to leave such valuable industrial property behind to become derelict, treasure trove, or res nullius. Res nullius is no owner. Again, I made it very clear that I never intended to leave any of my stuff behind in that hospital. But again, at 0 years old, it's kind of difficult to start laying claim to things. All right, here we go. Article 2. Nationals of each of the contracting countries shall in all other countries of the Union, as regards the protection of industrial property, enjoy the advantages that their respective laws now grant or may hereafter grant to their own nationals without any prejudice of the rights specially provided by the present convention. They're talking about the Hague Convention, by the way, at this point. Consequently, they shall have the same protection as the latter and the same legal remedy against any infringement of their rights, provided they observe the conditions and formalities imposed on subjects or citizens. Isn't it interesting that it's so easy to see? They're speaking about nationals, and they speak separately about conditions and formalities imposed on subjects or citizens. So you have three different positions: nationals, subjects, or citizens. In Article 2. It goes on to say, nevertheless, no condition as to the possession of a domicile or establishment in the country where the protection is claimed can be required of those who enjoy the benefits of the Union for the enjoyment of any industrial property rights. The provisions of the legislation of each of the contracting countries. Again, they're talking about countries here. Oh, Kurt, the United States is a corporation. They're talking about the country. They're specifically speaking about countries here. The United States of America is a country. The United States is a company. America is a landmass. Again, the United States is a company. The United States of America is a country. America is a landmass. They're talking about contracting countries right now. And when you're speaking of contracts, that would mean business, the business of the country. The business of the country. It says the provisions of the legislation of each of the contracting countries relative to judicial and administrative proceedings and to competent authority. Look at that. They just identified three different types of courts relative to judicial and administrative proceedings and to competent authority. Authority is ownership, authorship, author, authority. So they're talking about judicial, administrative, and authoritative. Three different potential courts. Again, when you own the property, when the property is what they're speaking about and you're the owner of this industrial property, your country is protecting you and your property. If you are not the owner, or if you can't prove to be the owner, the industrial property, i.e. your private capital and labor, falls into a trust. And that falls under administrative proceedings. So you can see they're talking about judicial, administrative, and authoritative. It goes on to say, as well as the choice of domicile or the appointment of an authorized agent, which may be required by the laws on industrial property, are expressly reserved. Again, it says, or the appointment of an authorized agent. Does a man need an agent? Does a living man need an agent? Does he act through agency, is my question. Or does he act upon his own property himself? A man doesn't have agency. He doesn't need agency. A sole ownership does not need agency. If somebody's acting on the behalf of somebody else or in the capacity for somebody else, that's agency. If you're acting on behalf of the state of Illinois or Illinois, that's agency. If Illinois licenses you to act upon property, even if it is your own property, you're acting through agency. But does a private man act through agency on his own property? See, what's going to happen is you should start to see that they're never speaking about your property. And if they're not speaking about your property, what the hell happened? How come your name is not your name? Why is Curtis Richard Kallenbach in a trust? Why is it being administrated over in a probate system, or why is there agency regarding Curtis Richard Kallenbach? There shouldn't be. So now, Article 3, nationals of countries not forming part of the Union or who are domiciled or have real and effective industrial or commercial establishments in the territory of any of the countries of the Union shall be assimilated to the nationals of the contracting countries. Assimilated. Last week I brought up the idea of an old Star Trek with the Borg. The Borg is where, I think I covered it last week, but it's where we or our personalities get assimilated into a singular unit. I call it the public pool. One giant neck to chop. One neck to chop. Anyway, that's what I think has happened, where we have become, our property was assimilated into a larger system. But it says nationals shall be assimilated to the nationals of the contracting countries. Okay, I'm going to go back to beginning here, because I'm going to start with the word national. National. This is some pretty crazy stuff. National, page 923 in Black's Fifth. Pertaining or relating to a nation as a whole. As a whole. So if I'm born on the soil of Illinois, 1818 Illinois, Illinois is now part of a more perfect union called the United States of America. The United States of America is that nation. But as an Illinoisan, I'm a national of those 50 states. But look how strange this goes real fast. Pertaining or relating to a nation as a whole, commonly applied in American law to institutions, laws, or affairs of the United States or its government, as opposed to those of the several states. National contemplates an activity with a nationwide scope. The term national, as used in the phrase national of the United States, is broader than the term citizen. It's broader. A citizen of the United States. But here's why you need to see this definition with your own eyes. It says, and again I quote, commonly applied in American law to institutions, American law to institutions, comma, laws, comma, or laws or affairs of the United States or its government. So it's actually saying the United States has a government. So the United States itself is not a government. It has a government. It says the affairs of the United States. What does the word affair mean? I'm going to go to it right now. Again, I wasn't planning on this. What does affair mean? Is it when you step out on your husband or wife? Sorry, I always have to throw some bad humor in here. Affair. What is an affair? Here it is. Black's page 53, affairs. In an inconclusive term, bringing within its scope and meaning anything that a person may do. A person's concerns in trade or property, business. Business. That which is done or to be done. General operations carried on by an employer. Affairs means business. Go back to national. It says, or affairs of the United States or its government. So it's talking about the business of the United States. And then it defines, it's basically saying that the United States is not the government. It has a government. It is not a government. So the business of the United States is a business. And then it says, or its government, as opposed to those of the several states. So the United States is being singled out here as a separate business entity. Now let's read it again with those eyes. National, pertaining or relating to a nation as a whole. Commonly applied in American law to institutions, laws, or affairs of the United States or its government, as opposed to those of the several states. National contemplates an activity with a nationwide scope. And it goes on to say the term national, as used in the phrase national of the United States, is broader than the term citizen. So a citizen of the United States is not a national of the United States. A national has other parts to it, other elements. A man can be a national of the United States, but a man couldn't be a citizen of the United States. not as contemplated in the 14th Amendment. A man can have a citizen of the United States, but he can't be a citizen of the United States. He can have one, but he can't be one. He can be a national of the United States, but he can't be a citizen of the United States. A citizen is a piece of property. I believe it's a membership. It's like having a membership card. I mean, when I go into my health club every day, I have to put a little thing up against an electronic eye, and it beeps me in. If I don't have that little thing against the electronic eye, it won't allow me in the doors. In other words, I have to have a membership to get in those doors. I believe a citizen, a 14th Amendment citizenship is the same thing. It's a membership to the United States Trade Organization. It is not the man himself. Again, I have a little thing on my fob, my key fob, that allows me in the doors. It is not me. I'm certainly not the membership. And I'm certainly not the key fob, which is, to me, it's very similar to what the citizenship would be. Nationals of each of the contracting countries and in all other countries of the Union as regards the protection of industrial property enjoy the advantages that their respective laws now grant or may hereafter grant. So they're talking about a grant to their own nationals. Their own nationals. They're talking about countries, the nationals of countries. Good. Second paragraph says, nevertheless, no condition as to the possession of a domicile or establishment in the country where protection is claimed. In the country where protection is claimed. What is the governments are instituted to protect private property. Governments. Again, going back to nationality, it says, or affairs of the United States or its government. As opposed to those of the several states. Those of the several states, meaning the affairs of the several states. What I'm getting at is they're splitting hairs here. They're speaking about countries and companies, business and countries, the business of a country. So when you hear people talking about, well, the United States is just a corporation. The United States of America is a country. And it has people in it. And those people have private property. And it's the business of that country to protect that private property. And they're doing a very good job of it right now. It feels horrible to us because we don't have any legitimate claims on anything. So when the cop is pulling us over, it's because we don't own any property. What they're doing is they're protecting the property that's in a trust. The trust that everybody wants to be involved in for some reason. The trust that everybody wants to be a beneficiary to for some reason. And the cops are protecting that beneficial position, that trust property. I prefer to actually have a legitimate claim upon it, so when a cop does consider pulling me over, he runs whatever tag that I have, and he goes, oh, do not stop, do not detain. I would prefer to not be dealing with this garbage at all. See, that's always been my goal. Lay claim to my property, do with it as I wish, and move on. I don't want to be treated like a child. Judicial, administrative, and competent authority. Let's see, it says conditions and for, I'm on Article 2, by the way, folks. It says legal remedy against any infringement of their rights. Now, it's funny, it says their rights, and they're talking about the nationals. What does it say here as a nation? Now, I just read the word national. Let's read the word nation back at page 923 in black. A people or aggregation of men. Does that sound like a fiction? It doesn't to me. Nation, a people or aggregation of men. That sounds like living beings to me. existing in the form of an organized jural society, usually inhabiting a distinct portion of the earth, speaking the same language, using the same customs, possessing historic continuity, all of the things I'll be covering this week and next week, and distinguished from other like groups by their racial origin and characteristics, and generally, but not necessarily, living under the same government and sovereignty, the same government. Folks, the Republic didn't go anywhere. You're just not party to it. The de facto, so-called de facto government is a business. People have got that confused because it's none of their business, sadly. The moment you claim your property, you're in business with the United States, and you're going to love it when you get there. Again, nation, a people or aggregation of men existing in the form of an organized jural society. You need to be a member of that society in order to be one of the people or part of that aggregation of men. If you can't prove your position, your status in that society, you are an outlaw. An outlaw. There's another word here in Article 2 that I think people should know. By the way, it says against any infringement of their rights, and they're speaking about the national. And a nation is made up of people or an aggregation of men. You have to fit that bill. You have to be one of those people or part of that aggregation of men to be considered to have your rights protected. It's funny how they ended the sentence by saying, provided they observe the conditions and formalities imposed on subjects or citizens. There's a differentiation there. Subjects or citizens. Infringement is a word that I think everybody should know. Infringe. Page 702. Infringement, a breaking into, a trespass or encroachment upon, a violation of a law, regulation, contract, or right, used especially of invasions of the rights secured by patents, copyrights, and trademarks. Does that sound like industrial property? Go back up to Article 1, patents, industrial designs, trademarks. So an infringement is a breaking into somebody's industrial property. Let me ask you a question. If you can't prove that you own anything, if you can't prove that it, i.e. the capital and labor you believe is yours, if you can't prove it's yours, are you not potentially breaking into somebody else's property? Are you potentially not trespassing on somebody else's property? If you can't prove it's yours, why do you think you're in court? Why do you think you're in court? Going back to the other earlier article I brought up, possession as a root of title. Both the court and the dissent assumed that the only proper mode of acquiring ownership of unowned things was taking possession of them. Have you taken possession of your capital and labor, of your industrial property? And if you're saying yes, prove it. I want to see evidence of it. Well, I know none exists in your hands, and I know you don't have any because I don't know anybody other than myself that actually has any physically in their possession. Let's keep going because I got a lot to do this week. Infringement. Infringement of copyright. Unauthorized use of copyrighted material. i.e. use without permission of copyright holder. Remember the 1790 Copyright Act are talking about books. The United States has the rights to this material, these books. What are the books? The registrations. What's in the registrar? What's in the registration? The book itself. Father's name is in the book. Have you ever laid claim to the succession of your father's name? Or are you a bastard? Because those are the only two positions. In 1921, and you can look into this, I'll put this up tonight when I get done talking, but there's something called the Shepard-Towner Act, and it came out in 1921. And it was basically help, government aid, government help for unwed women or children born out of wedlock or children born to mothers of no fathers. I mean, remember, 1921, there was a lot of wartime stuff going on. World War I just ended. So the whole idea is that they were trying to help these mothers that in need. So they came out with this thing called the Shepard-Towner Act, and they created government aid for unwed mothers and their children. It's funny, they say they got rid of it by 1929, but I'll be damned if they didn't come out with the birth certificate in 1933, which had the exact same imposition that the Shepard-Towner Act had in 1921. So with the birth record, the birth certificate itself, basically everybody using the birth record as it is right now is a bastard child. Everybody using an unclaimed position with no father attached to it is a bastard. So it's almost like everybody using a birth certificate falls under the Shepard-Towner Act. That's why it might be wise to actually read about it, because it's pretty disgusting. But just remember that when the Jesuits took over everything in the Civil War, they wanted everybody to be bending a knee to the Roman Catholic Church. That was the entire intent, to get everybody underneath the Roman Catholic system. That was their entire intent. And you know what? They've been very successful at it. Infringement. Unauthorized use of copyright material. By any chance, does anybody remember that the word illegal basically means unauthorized? That's all. It's illegal to use a legal name, Kurt. Illegal means nothing more than unauthorized. So to be unauthorized using a name, it would be illegal if you don't have the authority to do that. It would also be an infringement of copyright, which is called a breaking into, a trespass, or encroachment. You see, I believe that right now everybody in America using this property without having the proper authority are all criminals. I think everybody using a birth record right now without having the proper possession of it has committed a federal offense. Everybody's a felon in America right now. Without permission of the copyright holder. In determining whether there is a copyright infringement and not a fair use exemption, the factors to be considered include the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2, the nature of the copyrighted work. 3, the amount and sustainability of the portion used in relation to the copyrighted work as a whole. The amount and substantial, wow, that's a really weird word. Substantiality? I've never seen a word like that before. Of the portion. Substantiality of the portion used in relation to the copyrighted work as a whole. And 4, the effect of the use upon the potential market for or the value of the copyrighted work. I believe that every name that is on the birth record, in other words, Curtis Richard Kallenbach, is common law copyrighted. I believe it's already copyrighted. There's no reason to try to copyright it now. It's already copyrighted. All you have to do is get authorization, proper authorization to use it. And now you have authorization to use the copyrighted work. I think you just grab that authorization, by the way, by doing a few things. Let's keep going here. Infringement of patent, the unauthorized making, using, or selling for practical use or for profit an invention covered by a valid claim of a patent during the life of the patent. Infringement of trademark, the unauthorized use or colorable imitation of the mark already appropriated by another on goods of a similar class. There's a lot of words jumping out here, but it says imitation of the mark already appropriated by another. In other words, Curtis Richard Kallenbach, upper and lower case. That is a style. So an imitation of that could be Curtis Richard Kallenbach, all caps. And because Curtis Richard Kallenbach's already appropriated, it's already given over to some property on goods of a similar class. Similar. Not the same, but similar. Okay. Let's keep going here. Again, infringement. You can't read enough on infringement. Who is an infringer? Again, back at 702. One who infringes the rights secured by copyright, patent, or trademark holders. Secured. What we're going to find by the end of next week is that the birth record itself is a security. In fact, it's an issue of national security. An issue of national security. We just talked about the nation. The issue of national security is what that represents. That's a bond, or that's a share, a stock in the United States, but it's an issue of national security. Why? Because it's the entire financial system. That's the promissory aspect of the financial system. It's the thing that backs up everything in the United States. Everything. And so when you hear national security, you're thinking of armed guards and all kinds of stuff. It's not that. The national security is the financial aspect, or your promise to participate in the economic system. That's what it is. For you to put your industrial property in the mix, to offer it up to the United States, what do they call it? Full faith and credit? Is that what they call it? And that's your stake. That's your offering. Your full faith and credit is an issue of national security. It secures the nation and its finances. I'll take it one step further. I'll even say that Federal Reserve is exactly that. It's a reserve. It's money that can be available through, I think, usury or interest, but that's how I see it. An issue of national security. That's what the birth record identifies. All right. Article 2, Article 3, Article 4. Any person who has duly applied for a patent, the registration of utility model, industrial design or model, or trademark in one of the contracting countries, or his legal representative or assignee, shall enjoy, subject to the rights of third parties, for the purposes of registration in other countries, a right of priority during the periods hereinafter stated. I'm going to tear that. I need to tear that line up badly. I'm going to reread it a little faster so it has some flow to it. Article 4A. Any person who has duly applied for a patent, the registration of a utility model, industrial design or model, or trademark in one of the contracting countries, or his legal representative or assignee, shall enjoy, subject to the rights of third parties for the purposes of registration in other countries, a right of priority during the periods hereinafter stated. Wow, look at all those words in there. Registration. Registration. The registration of utility model, industrial design, or model, or trademark in one of the contracting countries. Any person who has duly applied for a patent, the registration, so that they're saying a patent, one, applied for a patent, or it says, comma, the registration of a utility model, industrial design, or model, or trademark in one of the contracting countries. Any person. And then it says, or his legal representative or assignee. So they're talking about any person, then they're talking about or his legal representative or assignee. Where did we see the word assignee last? In literary property. An author and his assigns. But anyway, so they're saying person, legal representative, or assignee. It's the registration I want to start at. Let's see. Registration. Let's go to registration because that's ultimately how you get back your commercial vessel. So let's go to registration real quick. Registration. But Kurt, registration to registrate is to give to the crown, it's to give to the king. Yeah, whatever. Registration. Recording is the first word. Basically to record something. Enrolling, inserting in an official register. Enrollment as registration of voters, registration for school, the act of making a list, catalog, schedule, or register, particularly of an official character or of making entries therein. In securities, the statutory procedure requiring the filing with the SEC of various documents, including a prospectus. But look what it says: recording, enrolling, inserting in an official register, enrollment as registration of voters, registration for school, an act of making a list, a catalog, schedule, or register, particularly of an official character. An official character. I don't see anywhere here that it says anything about giving anything up to the king. I wonder where that came from. Registrate, Kurt! Registrate! Boy, I get tired of that crap. But I like it. To record something. I mean, if I own something and I want everybody, the entire world to know it, why not put it out there for everybody to know it? Hey, listen, hands off. I own this piece of land here from these 3 points, these 4 points. If you cross those boundaries, that you're in my space. It's nice to let everybody know what's yours. So again, recording something, letting everybody know that it's yours. Even a name. Even a name. Any person who has duly applied for a patent, the registration of utility model, industrial design or model, or trademark. Here's my favorite one. Actually, I have two. Third parties and right of priority. I'm going to go to third parties first. And it says, shall enjoy subject to the rights of third parties. Third parties, what page is that on? Is that 1327? 1327. 1327. Third parties. One, not a party to an agreement or to a transaction, but who may have rights therein. A third party is not party to an agreement or to a transaction, but who may have rights therein. And right below that it says, third party beneficiary, one for whose benefit a promise is made in a contract, but who is not a party to the contract. A person not a party to an insurance contract who has legally enforceable rights thereunder. You know, when I look at the birth process again, I like to draw it out in my head when I say this. I always picture, baby over here and, off to the far left, fetal tissue, which I call mini-me. I just draw a smaller version of baby. And then I draw a shapeless mass for the maternal afterbirth. And I look at three different things here. The firstborn and then the afterbirth with two of its separate issues, two constituent parts, chorion and maternal. Isn't it funny how there's three of those? And they're talking about third party. See, I see that I am sort of the odd man out. Baby is sort of the odd man out. Because the afterbirth is unclaimed property. So somebody else comes in and decides that that's one man's trash is another man's treasure. Think about this. In the hospital, when mother leaves that mess behind on the floor, and somebody else has to come in and clean it up, call it a cleanup crew or call it a salvage operation. Somebody has to come in and salvage that mess. It's possible that nobody pays for the cleanup. So there's an outstanding bill, ultimately a lien on the property that was taken. Think about it. So there's DNA on the floor. And the DNA is both chorion, in other words, it's my DNA, fetal tissue, and it's my mother's tissue. Somebody comes in and cleans it up, hands the hospital a bill, or the hospital hands somebody a bill, and nobody pays it. And so in order for me to get that property back, in order for me to get my DNA back out of hock, out from underneath this lien, I would have to pay that. First, I would have to know that he had something of mine that he salvaged, and then I would have to come up with the money to pay the lien or the salvage bill. And until I do that, he basically has a lien against my DNA, or my mother's, or both. So you can see that even though I have nothing to do with the afterbirth material, and somebody contracted came in and cleaned it all up, me as genuine baby now get drawn in or pulled into some ridiculous claim that I don't even know exists. Some ridiculous trust that I don't even know exists. I become a third party because do I have an interest in that property? You better believe I do. By God, it's my DNA. So am I a third party of interest to any of those claims that have to do with the afterbirth? Yes, I do. Again, a third party, one not a party to an agreement or to a transaction, but who may have rights therein. Are all rights good? I mean, do I really even want rights over the left behind material? Realistically. If I had no rights in the material left behind in the hospital, would I be better off? Yes, I would. If I was not attached in any way, shape, or form to the material left behind in the hospital, would I be better off? You better believe I would be. They could never take me into a courtroom. Everything they're doing in court is based upon the left behind material. Everything. If they couldn't tie me to it and say, hey, you have a right to this, you have a stake in this. If all of it just got thrown away and never was ever thought of again, I would have my life free and clear. Instead, they create a new legal person out of it, call it Born Alive, and now I'm tied to this bullshit forever until I figure it out and take it back, make a claim on it, and take it out from underneath this ridiculous trust that should never exist. Third party. Firstborn baby, the genuine baby, and then the two others that come out after. Fetal tissue and maternal tissue. There are three right there. Right of priority. Let me go to priority. There might be, in fact, let me see if right of priority is even in here. I doubt it. It seems like a lot of words, but sometimes they do that kind of stuff, like true copy. Let's see, right of priority. Or right of way. Nope, I don't see it. There's right of possession, but not right of priority. So I'm going to go to priority. Okay, screw it. Let me just read right of possession, just because this is what I do. By accident, my eyes just fell on right of possession. Right of possession, right, which may reside in one man, while another has the actual possession, being the right to enter and turn out such actual occupant. The right of ejectment or eviction. An apparent right of possession is one which may be defeated by a better right. An actual right of possession is one which will stand the test against all opponents. Who actually occupies my DNA? Remember, occupancy is possession. Who actually, well, if they have the DNA in their possession and they have the original title, I'm in a pretty bad spot. Do they actually occupy? Do they possess the DNA? Yes. But where's the life at? The life is inside me. I'm actually physically occupying it because I possess it. And I, meaning I, possess it. Now I'm going to go to priority, because this is a really big deal here. Priority is a big deal. Priority. Okay, page 1074. Precedence. The very first word is precedence. Have you ever heard that in a court case? Have you ever heard that, watching Perry Mason? Something sets a precedence. Going before. A legal preference or precedence. When two persons have similar rights in respect of the same subject matter, but one is entitled to exercise his right to the exclusion of the other, he is said to have priority. The order in which claims may be satisfied out of the sale of real property. Okay, I'm going to go biological on you again. Dad lays with mom, his sperm fertilizes her ovum, producing the very first of its kind called the zygote. The zygote is me. It ultimately becomes me. It has both my father's DNA and my mother's DNA. It's a combination of mom and dad, and it turns into me. That's the first of its kind. That is, you can't get any more prior than that moment. That singularity, that moment that their DNA turned into my DNA. That's the first cause of everything. I got a couple fun questions for you right now then. That zygote that was created through mother and father's DNA, did that come before the maternal afterbirth or after? Well, the maternal afterbirth would not even have existed if it weren't for the fertilized egg, the fertilized ovum. So until the ovum is fertilized, there is no maternal placenta. There is no maternal afterbirth material generated. In other words, the zygote, me, create all subsequent happenings. Did the name Curtis Richard Kallenbach exist before the fertilized ovum? No. So even the title, Curtis Richard Kallenbach, comes after the fertilized ovum. Everything comes after the fertilized ovum. So me, living, genuine baby, firstborn, I actually have a right to everything that was generated or related to the fertilized ovum called the zygote, because I am the zygote. Now, problem is, a piece of that zygote splits off and becomes part of the afterbirth, and it's called the chorion. So now, a piece of that first cause, that very first claimant, we're talking about a priority. The chorion is also in a priority position, just like I am, because it's the same damn material. So if the chorion gets left behind, is there also a priority position for those that grab the waste material that includes the chorion? Yes. So there's two priority positions. Do you think they'd ever come forward with theirs if you claimed all of it? Hardly. Nobody could do that. No court is ever going to say, no, the chorion has a greater priority, a greater existence, greater weight than you do, Mr. Genuine Baby. They'll never bring it up. The case won't even come. There won't even be a case. That's my point. When you do a Minnesota Rule 220, what you're doing is you're pulling that other priority. In other words, the chorion itself, the fetal afterbirth tissue now, the lesser is pulled into the greater. So now there's only one singular prior position. One, you. And with that priority, you have precedent. You also have a legitimate claim to all subsequent creations. So that's why when a living man proves life, he's revested with this title. The moment you do what you need to do, the title, i.e. Curtis Richard Kallenbach, first, middle, last, whatever you want to call it, goes to the genuine baby, finally. And it's called the age of majority, too. What happens to the maternal afterbirth? Well, that's not part of the same claim. And that could be a problem down the road. So anyway, priority again, precedence. I think I should read precedence because you need to know how important this prior position, this priority position is. It's the most important of everything. Let's find precedence real quick. Precedent. Precedence. The act or state of going before, adjustment of place, the right of being first placed in a certain order. In logic, A to B to C, not A to C to B or B to A to C. First A, then B, then C. First zygote, then maternal afterbirth, then title. Precedence. Precedence. Patent of precedence. In Old English law, a grant, didn't I say that word earlier today? A grant from the crown to such barristers as it thinks proper to honor with that mark of distinction, whereby they are entitled to such rank and pre-audience as are assigned in their respective patents. Remember, you're going to find out that the trade name, copyright name, the assumed name, all that stuff, that's industrial property. It's all protected. It's already being protected. All you have to do is claim it. Precedent and adjudged case or decision of a court, considered as furnishing an example or authority for an identical or similar case afterwards arising or a similar question of law. Has anybody ever heard of the Erie Tompkins case in 1938, where they set a precedent of this? Every one of these birth certificated person cases, this has already been adjudicated. When they do a discovery and find out that this is an abandoned or unowned property, everything, it's called summary judgment. Everything falls exactly the way it's supposed to because it's already been adjudicated. It's already a done deal. If you have not done the proper claim on this property, it's already been adjudicated. It's going to go south real fast for everybody. So again, it says in a judged case, it's already happened. I don't care if something happens to you today. When you go before the judge, this particular matter was adjudged in 1938. It's already a done deal. They're not even going to bother with any other details. When they see this, when they do discovery, and they see this birth record, they go, oh, we have one of these. And it's already done. You can't argue it at that point, by the way. It says considered as furnishing an example or authority for an identical or similar case afterwards arising or a similar question of law. Courts attempt to decide cases on the basis of principles established in prior cases. Prior cases which are close in facts or legal principles to the case under consideration are called precedents. A rule of law established for the first time by a court for a particular type of case and thereafter referred to in deciding similar cases. A course of conduct once followed which may serve as a guide for future conduct. Precedent condition, such as must happen or be performed before an estate can vest or be enlarged. Listen to this. Precedent condition. Such must happen or be performed before an estate can vest or be enlarged. When a man proves life, he's revested with his title. He has to prove life. And what is the man? He's the larger of the two. There's the Chorion, mini-me, and then there's the living man. When the living man proves life, he's revested not only with the name, but he gets the rest of it. He's basically a whole man now. He gets the entire estate. It's called what? Fee simple, absolute. Precedent. There's another one, my favorite term is a priori. A priori is Latin, but I'm going to go to a priori right now. A priori. Okay, where is it here? Here it is. A priori is on page 94. Latin, from the cause to the effect, from what goes before. A term used in logic to denote an argument founded on analogy or abstract considerations. Abstract. Remember that the birth record is called an abstract. It's born of a memorial or memorandum, but they call it an abstract. I'll prove it to you in a second. Founded on analogy or abstract considerations, or one which, positing a general principle or admitted truth as a cause, proceeds to deduce from it the effects which must necessarily follow. Everything that's happening in that courtroom is logic. I know nobody wants to agree with this because they think the judges are just doing everything wrong. They're not. They're following pure logic. If there is a piece of paper that identifies an unclaimed estate, an estate that's subject to probate, it's obvious. They find, through discovery, they find this unclaimed estate, that's abandoned estate, that's in probate. They don't have any other options but to act upon it the way they do. You could be standing screaming in front of them, but it's not relevant because they have the facts in their hands. You never claim that position. When a man proves life, he's revested with his title. How bad do you want it? Then you got these morons out there saying that you're supposed to expatriate. Now, let me tell you something. You have never, ever been in the United States of America. If you were, it was momentary. A priori, from the cause to the effect, sperm enters ovum. Zygote is produced, the first of your kind. You, at that moment, are the first cause. You have an a priori claim upon everything that follows. Everything. And there is no trust. God, I get so tired of that crap. You know what? I'm gonna go to a trust book real quick just so I don't forget about this. Again, this is the 6th edition called Textbook on Trust, Paul Todd and Sarah Wilson. It is not at pCloud, but I did say it would be something you might want to have. Page 50, and the title is Nature and Classification of Trusts. This is unbelievable how simple this stuff is. Nature of a trust. It says, we saw in Chapter 1, a trust involves a division of the ownership of property. Let me say that again. A trust involves a division of the ownership of property. There has to be more than one owner in order for a trust to exist. How many people have a legitimate claim on your life? Is there a legitimate trust in your life? Why in the hell would anybody be working within a trust? Because what they're doing is they're denying their very existence. Or they're saying there's more than one of them. It's not possible for a trust to exist when there's sole ownership. And I can't imagine anybody wanting to share ownership of their life. It goes on to say, no trust is created. Whatever the intention of the settlor, by the way, it says the settlor is the original owner. Who's the original owner of the zygote? Who's the original a priori settlor? Who's the a priori position of the zygote? Who owns the zygote? Who owns the combination of mom and dad's DNA? Does dad own the zygote? No. He only has a 50% stake in it. Does mom own the zygote? No. She only has a 50% stake in it. Who has a 100% stake in it? I do. I'm the sole owner of that existence. It says no trust is created. Whatever the intention of the settlor, and again, the settlor is the original owner, whatever the intention of the settlor has manifested, unless legal title is vested, given to the trustee. Why would I give my property, my name, to anybody? Why would I give Curtis Richard Kallenbach to anybody to hold for me? I didn't. Somebody took it. Somebody attached it to some waste material that went unclaimed. And now they're administrating over this nonsense called Born Alive product. People, get your heads out of your asses when it comes to this trust shit. There can be no trust in a sole ownership. And there's no equity where there's no trust. That's going to keep coming up for the next 3 weeks. Right of priority. Prior, earlier, elder, preceding, superior in rank. right or time as prior lien, mortgage, or judgment. Prior noun, the chief of a convent, next in dignity to an abbot. Prior, Latin, the former, earlier, preceding, preferable, or preferred. Don't you want to be in that position? Why would anybody choose to split up their existence? It's beyond me. B, I'm talking Article 4 here. Consequently, subsequent filing in any of the other countries of the Union before the expiration of these periods shall not be invalidated through any acts accomplished in the interval, either particularly by another filing, by publication of the invention, or by the working of it, by the sale of copies of the design or model, or by use of the trademark. It says, subsequent filing in any of the other countries of the Union before the expiration shall not be invalidated through any acts accomplished in the interval. Okay, publication of the invention. Where it says publication of the invention, can anybody think of what that first publication would look like or what it would be called? Does anybody remember the birth announcement, where everybody's all pumped and stoked about their little baby's name being in the paper? That's a first publication. You know what that announcement is? Let's go to the word announcement real quick and see what it says here. To be announced. This is on page 82. A decision is announced preventing non-suit when court's conclusion on issue tried is made known from bench or by any publication, oral or written, even if judgment has not been rendered. It says a decision is announced. A decision is announced, preventing non-suit. Non-suit, preventing non-suit. Isn't that funny how they say things? Preventing non-suit. You can't stop it from happening at this point. So a birth announcement, realistically, why would you want your child's name in the newspaper? Why would you want it to be put into the public domain? You wouldn't if you really knew copyright law. C, the above-mentioned periods of priority shall be 12 months for patents and utility models and 6 months for industrial designs and models and trademarks. These periods shall start from the date of filing of the first application in a country of the Union. The day of filing is not counted in this period. Again, these are just all details, but you're gonna see how this all fits together. If the last day of the period is these known in the country where protection is claimed, the period shall be extended until the next working day. Any person desiring to take advantage of the priority of a previous application must make a declaration giving particulars as to the date of such application and the country in which it was made. Each country will determine for itself the latest date at which such declaration must be made. This really concerns me, by the way. A declaration giving particulars. Well, first of all, I would have to go to the word declaration. To declare something. To declare something. I've gone through this little story all the time to try to get people to understand custom. When when she steps from the soil of Illinois in the Union, the United States of America, into this business zone called Swedish American Hospital, does she stop by custom and declare the package in her womb? No. When she delivers the package inside that territory, does she call up customs right then and there and declare what was delivered as her property? No. When she brings baby home, does she stop by customs and declare baby going back into the United States of America? No. What about the material that was left behind? Did that ever get declared? Did the afterbirth chorion or the afterbirth maternal material. Did that get declared? No. Did the title that was left behind on paper get declared? No. So let's look up declaration real quick. Can you see how easy it is for them to pick up this property and say, where's the owner? To declare something. A declaration is pretty important. Okay, declaration. Page 367. Look at this. Page 367. A declaration, I'm not going to go to the top yet, I'm going to go down. In the law of evidence, an unsworn statement or narration of facts made by the party to the transaction or by one who has an interest in the existence of the facts recounted. A declaration in the law of evidence, an unsworn statement or narration of facts made by a party to the transaction or by one who has an interest in the existence of the facts recounted. Also, similar statements made by persons since deceased, which are admissible in evidence in some cases, contrary to the general rule. Right below that, listing by person entering United States of merchandise or other goods brought into country by him. Did Mom do that? Did Mom do that? Listing. By the way, what is another word? We saw the word list earlier tonight. Wasn't it under registration? Isn't to register a listing as well? So look what it says. A listing by person entering United States of merchandise or other goods brought into country by him. It says into country, by the way. So they're definitely identifying. A listing by person entering United States of merchandise or other goods brought into country by him. A document by the owner of property, which is recorded in order to establish a legal order upon the property, such as a condominium, by a declaration of condominium, or master deed. A system of cross easements, by a declaration of easements, or a homeowners association. Don't get confused with all that other garbage, that smoke and mirrors. All you have to read is this: a document by the owner of property which is recorded in order to establish a legal order upon the property. Legal order. Does that sound like priority? Yes. Declaration itself at the top, it says, in common law pleading, the first of the pleadings on the part of the plaintiff in an action at law. Folks, a declaration giving particulars as to the date of such application and the country in which it was made. That is a certificate, that is a live birth record. That is a live birth record. It has witnesses, it has location, it has the particulars, in other words, the size and weight and the color and the male, female. It has everything it needs to be a declaration. Has anybody ever claimed that? Do you know of anybody that's ever gone in and legitimately claimed that declaration, that certificate of that live birth record? That's what Minnesota Rule 220 is. By affidavit, you're declaring that you are one of the owners of that property. Remember, there's only two potential owners, you and Mom. You're the owner of the fetal tissue, Mom's the owner of the maternal tissue. There's only two potential owners. Only two people can claim it. Remember, it cannot be vested in anybody else. And ultimately, Mom can't claim you because you're separate from Mom. You have distinctive DNA. She cannot make a claim upon you. You see how simple this is getting? Each country will determine for itself the latest date at which such declaration must be made. I think I think it was 21 years, but I think I think the date that they're giving is for the waste material, the maternal material, because they can't put a date on your DNA. They cannot put a date or limitation, a date of limitation on you claiming your own life. You can be gone forever. You could be gone for 100 years and show up and say, honey, I'm home. There's a movie out there. It's boring as hell, but and very tedious. But it's one with Tom Hanks, and he gets lost. His plane crashes, and he's stuck on an island. And while he's stuck on an island, everybody thinks he's dead, and his wife goes on and marries another man. So he loses the life that he had before his plane went down. That's kind of what happens to us. Everything gets sold off. We're missing. We're gone. Everything gets done. Everything gets thrown into probate, and all of our shit gets sold off. That actually has already happened. I guarantee it's happened. Which is why they fight so hard to keep this shit under wraps. Because it's already been sold out from under you. The particulars referred to shall be stated in the publications issued by the competent authority. The competent authority is your parents. And in particular to the patents issued and the specific specifications related thereto. The contracting countries may require any person making a declaration of priority to produce a copy of the application previously made. The copy, certified as correct by the authority receiving this demand, shall not require any legal authentication. Shall not require any legal authentication. So is a authenticated birth record required, realistically? Do you have to go through all those hoops, jump through all that stuff to get an authenticated birth record? No. No. The problem is, usually the courts will demand at least a certified copy, but remember that the authentication process gives legal weight of an original. That's the only reason to do an authentication process, is because it gives legal weight as an original. Is it even possible you're ever going to be able to get your hands on an original? No. My guess is they burned that a long time ago. They got rid of that a long time ago. They don't want any evidence of what has transpired. The copy certified as correct by the authority receiving this demand shall not require any legal authentication, and in any circumstances be filed at any time, can be filed at any time within the period of 3 months from the lodging of the last application. They may also require that the declaration shall be accompanied by a certificate by the proper authority showing the date of application and also by the translation. Listen, the birth record identifies the country of origin. The one I have actually has, I'm looking at it right now, it doesn't say the United States. It says Illinois. It says Winnebago, the county, upper lowercase. It says Illinois, upper lowercase. Illinois, it doesn't say state of Illinois, it says Illinois. Where's Illinois located? It's one of the 50 states of the Union, which is the United States of America. This document evidences me inside, or something inside the United States of America. If I don't lay claim to this position, if I don't pull myself or pull this to me, this record, if it's not part of my life, I have no claim within the boundaries of the United States of America, and I am an alien. If I don't tie myself to this record, if I am forever missing, presumed dead, because I have not tied myself to this record, I will forever be an alien. And that's what's happening to everybody. Everybody is an alien. So when Donald Trump is talking about the aliens, don't think he's talking about the Mexicans. He's talking about those that have yet to claim their true position within the United States of America, because they created a system where nobody is entitled to be here. Everybody has failed to claim their position. And ultimately what they did prior to or during the Civil War is they created a way for everybody to expatriate. In other words, by doing nothing, you end up expatriating from the United States of America. You expatriate. You go to another place. You go to another government. See, so everybody that thinks that expatriation is the answer, what they don't realize is that they've already expatriated through their negligence. By not claiming the position within the United States of America, you have fallen away or fallen outside of the United States of America. Or I always think of it as you're kind of stuck in a political asylum, an institution, a political asylum, because you have yet to claim your birthright. You haven't yet claimed your birthright. By the way, and what in your birthright itself, it's tied to all of the fruits of your labor, the usufruct, the industrial property. If you don't have a name, if you can't claim a legitimate position, and all your stuff is under the care of the church warden, then you're not even entitled to the industrial property of your life. See, that's the whole thing. Everything is connected. Your property is connected to your claim upon your life. Let's keep going. Here's an interesting word here down at the bottom of Article 4. It says, lodging of the last application. From the lodging of the last application. I'm going to get on the computer here for a second, and I'm going to go to Webster's 1828, if I can get online. Webster's 1828. And I'm going to go and see about, I'm going to see what, I'm going to go to certificate first, because they use an interesting word there, certificate. They use the word lodge. It says certificate, the verb transitive. It says to give a certificate, semicolon. To lodge a certificate with the proper officer. Lodge. When you hear the word lodge, what do you think of? Like an overnight stay? Because that's what it is. To lodge it is to give it to somebody for a stay, a keep. And it says to lodge a certificate, meaning that you're giving it to them for them to put up for the night, so to speak, or many successive nights. To lodge. I'm going to go now and look up the word lodge. At the same thing, I'm going to use the same dictionary, Webster's 1828, and I'm just going to type in lodge. See what it says. Lodge. Look at this. To set, comma, lay or deposit for keeping or preservation, comma, for a longer or shorter time. The men lodge their arms in the arsenal. 2, to place, to plant, to infix. He lodged an arrow in a tender breast. These are the examples. 3, to fix, to settle in the heart, mind, or memory. Oh my God, does it say that? To fix, semicolon, to settle in the heart, comma, mind, comma, or memory. If you don't have a memory of something, if there's no way for me to remember my showing up on planet Earth, then the only thing that I have is the memorial, the thing that helps me to remember that moment, and that's called the birth record. If I don't have access or have yet to claim the birth record through an affidavit at this point, if I don't do that, I still have no memory of that occasion, of that happening. everything out of my mouth is hearsay. So I cannot definitively say that September 19th, 1960 at 3:50 a.m. I arrived here. It's hearsay. From my mouth, it's hearsay. But on this birth record, there are 3 witnesses. So let's go back to the word lodge here. It says to fix, to settle in the heart, mind, or memory. To lodge. Look at this, number 4. To furnish with a temporary habitation or with an accommodation for a night. He lodged the prince a month and a week or a night. To harbor, to cover, to afford place to throw in or on, to throw down, to lay flat. To lodge, to reside, to dwell, to rest in a place. To rest or dwell for a time as for a night, a week, a month. To fall flat. Lodge a noun, a small house in a park or a forest. A temporary place of rest at night. A small house or tenement appended to a larger. Doesn't that sound like it? It says appended, appurtenant, connected to. A small house connected to a larger house. A den, a cave, any place where a wild beast dwells. A wild beast. To lodge. They may also require that the declaration shall be accompanied by a certificate by the proper authority showing the date of application and also by a translation. Next page. No other formalities may be required for the declaration of priority at the time of application. Each of the contracting countries shall decide for itself what consequences shall follow the omission of the formalities prescribed by the present article. But such consequence shall in no case be more serious than the loss of the right of priority. Are you kidding me? It says, the consequences shall follow the omission of the formalities prescribed by the present article. Omission. In other words, what happens if you don't do this? What happens if you omit or forget to do something? Omission. Let's see what it says. Omission. Page. Omit. Oh. Omission, omissio, omission, the neglect to perform what the law requires. An intentional or unintentional failure to act, which may or may not impose criminal liability depending upon the existence vel non of a duty to act under the circumstances. Let me ask you something. Whose duty would you say it is to take care of your body? Who has a duty to take care of your body? Just a question. Omission. In other words, we forget, since we've never been told. I mean, remember, this is all about deception. The intent behind this is pretty ugly. But we need to stop chasing or following the guide, the lemming, the failure in front of us. We need to start thinking for ourselves. It says, but the consequence, this is huge, by the way, what I'm about to read. It says, but such consequence, and they make such light of it, by the way. But such consequence shall in no case be more serious than the loss of a right of priority. The loss of the right of priority. The loss of the right of priority. You know what? Priority is everything. Priority is everything. Let's go just because I know it's an important word, I'm going to go to the word paramount. Paramount. I remember back in the early 70s, a neighbor kid that was about 5 years older than me had a Schwinn Paramount. It's a bicycle. And it was a pretty nice bike. I mean, it was one of the top of the, I think it was the top of the line Schwinn at the time. In other words, it was the top of the line. It was Paramount. Paramount. There it is. Paramount. Okay. Paramount. Above, upwards, higher, superior, preeminent, of the highest rank or nature. Look at this. Paramount equity, an equitable right or claim which is prior. Paramount equity, an equitable right or claim which is prior. There's nothing before that. Superior or preferable to that which it is compared. Do you have a claim upon mother's property? No. In other words, can you claim the afterbirth, the maternal afterbirth? No. You can't. But since it creates a secondary position, in other words, remember there are two things underneath the title Curtis Richard Kallenbach. There are two different elements, fetal tissue, maternal tissue. They both fall under Curtis Richard Kallenbach. When I prove life, I get Curtis Richard Kallenbach, but it leaves this other property, it leaves this other thing, mother's tissue, out there. What did they do with that? They deposited that and created the ship of state, the commercial vessel. That's the one that is the security. That's the real security. The mothership. That's the one that you get the assumed name for. And that is where you would have a paramount equitable claim, because it can never be your property. That stays in the trust of the United States of America. Is it your property? No. You're sole ownership over your stuff. But since it's tied to that birth, that moment, that arrival, and they gave it the all caps name. They gave it Curtis Richard Kallenbach. All caps. That's the security to the all caps name, is the mother vessel. I am not the security to it. The mother ship, the mother material is the security for that vessel. So when I do an assumed name and pull that name back to me, because of where it fits in chronologically, I have a prior or a paramount equitable claim on the mother ship. I do. Who has a prior? What came first, the zygote or the maternal afterbirth? The zygote, which is me. So I actually have even a legitimate claim upon the product, even though it's my mother's DNA. She created that vessel for me. She created it specifically for that zygote, which is me. Is it my property? No. But did she create it for me? Yes. Was it created before me? No. I was first, which means I am prior. I am prior. Would the maternal afterbirth exist without me? No, it would not. Because she's not going to create the maternal afterbirth without the baby. Hope this isn't too much biology, but it's the most important stuff out there. Again, they make light of this. It says, but such consequence shall in no case be more serious than the loss of the right of priority. That is the most serious. Unless, of course, you're some third party or you're somebody that really has no true stake in it. To me, the most important position is the prior. is the a priori position. There's no more paramount position than that. It says at later stages, further proof in support of the application may be required at later stages. Let me grab some water here real quick. E, where an application is filed in a country for the registration of an industrial design or model by virtue of a right of priority based on the registration of a utility model, the period of priority shall not exceed that fixed for industrial designs and models. What's interesting is next week, I'm talking about industrial property this week. Next week, I'm going to be talking about cultural property. Why is that important? What is cultural property? It's property that can be claimed by a culture, a country, a government. Americana is called cultural property. So anything that can fall under the heading of Americana can be claimed as cultural property by somebody. Is the citizen of Illinois my property or cultural property of Illinois? Yes, it's cultural property of Illinois. So I can have a stake in that Illinois citizenship, but I can't own it. It's cultural property of Illinois. And by default, because Illinois is the cultural property of the United States of America, then the cultural property of Illinois would also be the cultural property of the United States of America. So the citizen of Illinois is property of the United States of America by default. Would they want to be protecting their property? You better believe it. How in the world would I have a stake in the cultural property of Illinois? By being born to the soil of Illinois. Am I part of the cultural property of Illinois? No, but my person is. Is it starting to make sense here? Let's continue. Let's see. Furthermore, it is allowable to deposit in a country. By the way, the word lodge, back there at Webster's 1828, it says, right here at number, I think it said deposit. There it is, number 1, to set, lay, or deposit for keeping or preservation for a longer or shorter time. The men lodge their arms in the arsenal. To deposit is a lodge, or to lodge something is to deposit it. It says, furthermore, it is allowable to deposit in a country a utility model by virtue of rights of priority based on a patent application and vice versa. What's a utility model? We already went over model. Let's just see what utility is. Utility. In patent law, industrial value. The capability of being so applied in practical affairs, remember affairs is business, practical affairs as to prove advantageous in the ordinary pursuits of life or add to the enjoyment of mankind. Utility. The absence of frivolity and mischievousness, the utility for some beneficial purpose, but there is no utility if the invention can be used only to commit a fraud with. Wow, that's a hell of a line. But there is no utility if the invention can be used only to commit a fraud with. By the way, I've never seen professionals end with a preposition like that and put a period. To end with period is just a weird way, but it says, but there is no utility if the invention can be used only to commit a fraud with. or for some other immoral purpose, or can be used only for gambling purposes in saloons, or if the invention is dangerous in its use. Utility is established if only partial success is attained. Partial success. Remember succession? Success? Let's go to success real quick. Running out of time tonight. Success. Succession is the devolution of title to property under the law of descent and distribution. What is success? Successio. In the civil law, a coming in place of another on his decease, a coming into the estate which a deceased person had at the time of his death. This was either by virtue of an express appointment of the deceased person by his will, and succession again. So we're talking about father to son, father to son. The last name is a succession. The act or right of a legal or official investment with the predecessor's office, dignity, possession, or function. It's your father's name. It's a dignity. It's an investment. It's clothing. It clothes you in a capacity as a legitimate son that's in an inheritable position. Utility. Utility is established if only partial success is attained. Partial success. Could they, if they split you or split you away from father, if the father's name goes into the Library of Congress, which it does, but it's actually away from the family. Remember, I told you early tonight that what they did is through the birth records actually separated ultimately the father's name from the child and the mother through the Shepherd-Towner Act. So the father's name goes to another place. It goes to another place. It's separated. Partial success, meaning the name goes to a piece, but not to the whole. Remember, your father's name is also called the house. Let me do that real quick because there's some really weird stuff when you start to see this. The word house, and again, I never could understand why they would do this. It says a household, a family living together. Those who dwell, remember dwell is also under lodge. Those who dwell, so remember that to dwell is to lodge as well. Those who dwell under the same roof and compose a family. A man's family living together constitutes his household, though he may have gone to another state. He, the father. The father's name has been separated from the family, people. Partial success is probably when a name is granted through some probate, some estate work. But for me to have my father's name or to carry my father's name, I would be in an inheritable position. I would get the entirety of my father's estate, which I believe I already have by the few acts that I've done. Let's keep going. Again, it says, furthermore, it is allowable to deposit in a country, a utility model by virtue of rights of priority based on a patent application and vice versa. Based on a patent application. Rights of priority based. What is the word base? Base. I don't even know if they have the word base in here. Base, yeah, they do. Low in place or position. Inferior, servile, of subordinate degree, impure, adulterated, or alloyed. Based virtue of rights of priority based on a patent application and vice versa. Low in place or position, inferior, servile, of subordinate degree. Furthermore, it is allowable to deposit in a country a utility model by virtue of rights of priority based on a patent application. F. If an application for a patent contains claims for multiple priority. I'm going to finish this one tonight. If an application for patent contains claims for multiple priority, or if examination discloses that the application contains more than one invention, the competent authorities must at least allow the applicant to divide it, subject to conditions of internal legislation, reserving as date of each divisional application the date of the initial application, and, if there is occasion for it, the benefits of a right of priority. Allow, it says, contain more than one invention. You got to think that there are, to me, when I look at the birth product, I see at least 5 potential positions. I said this early on, probably 2 weeks ago. 5 potential positions. First, baby. The only legitimate, genuine position, baby. That's one. Then the second mass that comes out, number 2 comes out, which is the afterbirth. And the afterbirth has 2 separate elements to it. Fetal tissue, called the chorion, and maternal tissue. So that's 3. Baby, chorion, and maternal tissue. There's 3 right there. 3 potential claimants. The fourth is the title itself. Curtis Richard Kallenbach. When Mom puts pen to paper as an author and creates that new character, that new title. Now there's 4 things that arrive that day. And I believe the 5th thing is the registration itself of something, which I think is the maternal afterbirth. So there's 5 different things in my mind right off the top. So now when I reread this, it says more than one invention. I'm going to finish probably tonight with the word invention. I'm getting really stuffed up right now, so it's just getting hard to talk. Invention. In patent law, the act of or operation of finding out something new. Something new. So the day all of these things arrive, are they all new? Is baby new? Yes. Is the chorion new? Yes. Is the maternal afterbirth new? Yes. Is the title new? Yes. Is the registration of some other new all caps vessel new? Yes. So, the act or operation of finding out something new. The process of contriving and producing something not previously known or existing by the exercise of independent investigation and experiment. Also, the article or contrivance or composition so invented. Remember the word composition? First, middle, last is a composition. So even the title, the name itself, is considered a composition. Invention is a concept, a thing involved in the mind. It is not a revelation of something which exists and was unknown, but is creation of something which did not exist before, possessing elements of novelty, which is really funny because I remember an attorney once telling a friend of mine, wow, what a novel idea. Curtis Richard Kallenbach is the title to a life story. Is that not a novel idea? God, I just can't believe some of these attorneys. Smug bastards. Elements of novelty and utility in kind. Kind. The German definition of Kinde, or kind, is child. K-I-N-D means child in German. Utility in kind and measure different from and greater than the art might expect from skilled workers. The finding out, the contriving, the creating of something which did not exist and was not known before. Not known before. I'm going to let you guys read the rest of that. But invention. It says, and to finish up on, I guess it would be Article 4 here. It says, if an application for a patent contains claims for multiple priority, or if examination discloses that the application contains more than one invention, my God, I can see 5 inventions. The competent authorities must at least allow the applicant to divide it. There's your trust. There's your trust. Going back to the trust handbook, what does it say? Trust. A trust involves a division of ownership of property. That's right out of, again, Textbook on Trust, Paul Todd and Sarah Wilson, page 50. A trust involves a division of the ownership of property. So again, it says, more than one invention, the competent authorities must at least allow the applicant to divide it, subject to the conditions of internal legislation. By the way, internal legislation, what do they create? Statute. Statute, which is what the birth record is called. Reserving as date of each divisional application the date of the initial application and, if there is occasion for it, the benefits of the right of priority. So if you thought of priority, let's finish with this as far as priority. Of the 5 things, the 5 things that come up that are a product of that birth, your arrival, there's 5 things, let's say. In order of their existence, number 1 has to be baby and the chorion, because they both are products of the zygote. So baby and chorion are first position. The maternal afterbirth is the second position, because it was created soon after the zygote was created. So it's baby and chorion as position 1, because they're both a product of the zygote. Maternal afterbirth is position 2. The title, Curtis Richard Kallenbach, when mom puts pen to paper in the hospital, is 3. And the registration of that title would be 4. So in priority is genuine baby for sure. And of course, when you lay claim to the genuine baby, the living baby, Seneca Vice says, when a man proves life, he's revested with his title. Everything collapses the moment you do a proper Minnesota Rule 220. Everything collapses. And that trust property, the maternal afterbirth, you could still go get that through an assumed name. And I would that's probably an advisable thing, because then you lay claim to everything, 100% of that happening, the birth happening. So anyway, on that note, hopefully I won't be so stuffed up tomorrow night, but I'm telling you, industrial property is your private property, and you got to claim it. You are going to find yourself tied to cultural property next week, but that's your position within the United States of America, which then the United States of America protects your private industrial property. You've got to participate. You cannot be stateless. You have to be willing to participate in some form of state. by the way, you do it all. When you do a proper claim on one, you make a proper claim on all. So anyway, on that note, I'm getting out of here. I'm going to go have another cup of tea at this point, and I'll see you guys tomorrow night.